Okay, so let's get started. So anyone who's here before heard William speaking. My name is David Barros. I'm also with Capell, Barnett, Matalon, and Schoenfeld. I am a partner in the not-for-profit religious organizations group. And we're going to be talking about something that maybe a lot of people don't want to talk about, but we think is important. It's talking about legacy, and if you're at a point where you're planning to dissolve your religious corporation. So what is a dissolution? William, what's a dissolution?
So a dissolution is the formal legal process by which a corporation will unwind its affairs, transfer its assets, and essentially, we talked about before constituting your organization with a certificate of a corporation, unconstitute your organization.
Yeah, and just like we heard before, sort of what regulates this primarily for religious organizations is the Religious Corporations Law, also not-for-profit corporations law, but in this case, we're going to focus on Section 18 of the law. And when is the best time to think about this?
I believe the term of art is sooner rather than later. But no, you should think about this soon, because I think what people struggle with is the fact that this process takes a long time. People are like, we're going to close, and all we got to do is shut the door, and then we'll walk away, and then we'll be done. It's in God's hands.
Yeah.
I'm here to tell you that while it's in God's hands, it's still in your hands too. And you've got to see it to the end. And there's a lot of things, all of the charitable assets that you have, that you need to make sure are properly disposed of and taken care of in connection with your fiduciary duties if you're a member of the board of trustees. And also in fulfillment of your own sort of obligations to the charitable donations that your organization received.
And I generally, when people come to us to talk about this is what I see it is, you're no longer acting in your corporate capacity, right? So what is that, right? You no longer are having board meetings, you're not having member meetings, you no longer have a full board. And also, for some reason, you can no longer keep up with religious services, right? Say you can't even afford to hire a pastor to have services on a regular basis. Stuff of that nature, that's when you start thinking about, okay, what is the legacy we want here for this church? What is or organization, and how are we going to sort of plan for that future event?
And I want to be clear here, because dissolutions, we live in a world of reality of church closures, and that is a sad and unfortunate thing, that houses of worship are closing. But dissolutions, as with anything else, are an opportunity. And that's why the title of the presentation is Thinking About Your Legacy. Because not only do you need to be a steward of this to complete your fiduciary obligations, but that opportunity is the way that you make sure that even though your organization is dissolving, that its mission and the things that it stands for are preserved.
It's about planning, really. It's really about planning and making sure that sort of the assets you have are actually being utilized in a way that oftentimes plays it forward to the next generation of organizations. But it's also, you're sort of taking you're instead of it just, you have only 2 more members and now you sort of figure out what to do, it's really planning ahead of time, making sure the consensus is there from your members so everyone feels good about the decisions being made. One thing we did want to talk about, because oftentimes there's a lot of denominations that say, okay, the church has closed, so we're dissolved. That's not necessarily the case, right? As William pointed out, the dissolution process is sort of the legal process to basically tell the state and everyone out there that you are no longer an entity, that you can no longer sort of bind that organization, and that the actual duties of the board, they no longer have any duties to the actual larger organization. So you're cutting ties, telling everyone, putting them on notice that we are actually legally dissolving, but closure is slightly different, right? Closure is you can no longer have religious service or you're not having religious service. So we do want to make that distinction between the two. And the big thing why dissolve is because of the liability aspect, right? So you close your doors, maybe you've actually already sold your property, but there's still a legal entity still existing with the state. You want to sort of cut off the liability aspect of things. And the board of directors that were there at the end also want to know that there's nothing, I no longer have any responsibility to the organization or to the members going forward. It's the legal process, again, to actually formally no longer exist.
I will also say, for members of church judicatories. This is also relevant for you, because if we go to the earlier slide where we said closure, unfortunately, not every member of every church across the New York City area is here today, and they didn't hear what we just said about closure. So they may still close their doors. What that means, and this can happen based on your own ecclesial governance, is the amount of connection you have to the property may open you up to a liability. And so it's important for you to keep in mind, as a denomination that has jurisdiction over a corporation, that you may want to dissolve it, because what you are doing if you don't is you run the risk of liability that, because you've taken over the corporation through your ecclesial polity, that you actually may be the recipient of liability thereafter. So it's also important for you to consider, as not only the church, but also the people who are the greater stewards of the church, you should be dissolving these corporations in addition to taking over the property, because of the fact of what you want to close the opportunity for liability, because your ecclesiastical process has opened you up to it.
Yeah, it's a clean cut. You want to make sure the public knows that maybe someone who's saying that they're still a board member sort of entered into agreement after it was formally closed, but that might have been binding, might not. You just want to have that time frame. And you want to put the public on notice that you're actually closing. I think this goes in hand with what William was saying earlier. You also you have to submit the certificate of dissolution with the county, so everyone's on notice that this is no longer a validly existing entity.
Okay.
Are we doing questions, David, or are we going to the end?
Let's go for it.
Let's go.
Yeah.
So I think you've heard some of these questions, but I'm going to ask them again. So if we're doing ecclesiastical closing and that's finished, so we don't, this is a Presbyterian church, so the denomination, the presbytery owns the building, but the deed is in the name of the church. So when should we transfer the deed in this process? Do we wait for corporate dissolution, or we do it before?
That is a question that depends on the fact and circumstances of the property itself, and I would recommend that you consult with your legal counsel, because there's a lot of situations that may come into effect.
Sometimes it really depends, obviously, denomination wide, right? So some denominations basically say that an individual congregation is holding the property in trust for a larger denomination, right? In that scenario, it's sort of that transfer just happens automatically, and there's no need to go through the legal process to transfer that, right? It happens ecclesiastically, it's sort of well-formed, right? However, if you don't have that process in place through your denomination, then really the only way to transfer the property is through the court getting AG approval or a dissolution process, right? So you need that formal process. It really depends on each organization and sort of how it's made up. Yeah, so you at that point, if you have part of one of those larger denominations and the property transfers because there's a closure and that sort of governing body has deemed it so, right? That entity, the legal entity, still exists, but that property is no longer associated with that legal entity.
And also, I think what's important is just one of the reasons why is by transferring property in the state of New York, you trigger other regulatory actions, and whether or not you actually formally do it, through virtue of operation of law, you may have control. And so there may be reasons why you want to avoid those triggers, right? You may want to avoid additional things until a later date, right? I'm not trying to say that you're not going to deal with those things, but it may be prudent to wait to a later date or time it in a different way.
And I think, once again, thinking about a plan of dissolution really needs to be thoughtful. You have to take into consideration what are the restrictions on the property, especially if you're within a larger denomination. Understand sort of what happens if you close, no longer have services. Understanding that process, it's really a lot of planning ahead, and that's sort of why we say get ahead of it, understand sort of where the property is going to go, and then how you're going to address the liabilities. Say if all the property has been transferred, there's still outstanding liabilities. We still need to figure out what the plan is there, right?
That's the important thing, right? Because when people talk about dissolutions, everyone focuses on the assets of the assets, right? And the assets are important. Like, don't get me wrong, they're very important, but that's only half the picture. The liabilities are also, and that's why they're so important, is you have to make sure that you're addressing the liabilities, and that way, and like everyone here, we live in a world of, for instance, like the sexual stall stuff that's going on, right? With that's being opened, and the traditional statutory of limitations is being expanded. There's reasons to actually that you may want to close this corporate liability in the current day and age that we live in.
Yeah, so I'm in UCC, and part of like middle judicatory, and we often say to churches, put in your bylaws what you want to happen to your assets. Based on what you're saying now and it being a bigger conversation than that, is there any recommended language of something we could say to them so that we make sure all the steps are completed? Like, is there another document that they could like have on file or something that would state this?
Yes. You want to talk about the bylaws component, because in most bylaws they do,
So as a requirement of your certificate of incorporation, in order to be compliant with the Internal Revenue Service, there's a requirement, and this also matters for your property tax exemption. There's actually instances where the Department of Finance will look to make sure that's there as well, is that upon the dissolution of your organization, the assets of the corporation must go to a 501c3. That must be in there. That may not necessarily be in the bylaws, it should be in the certificate of incorporation. So as a threshold matter, 501c3. The next part of it really comes to a complication. I will say a lot of denominations like to have their name as that organization, and if that's something that the denomination wants to work with the congregation to do, that's a good thing to have. But I will say the difficult thing about putting it in your bylaws is what happens when it's time to dissolve and there's only 6 people and you're not able to amend your bylaws, and that was 50 years ago, and what you want now is not what you want. What you wanted then is not what you want now. So yes, it can be a good thing because it means that the desires of those people 50 years ago are controlling you, and that could be a good thing. There are times where you may want that. However, it means that the viewpoints of 50 years ago may be controlling you.
I think,
and there are times when you don't want that.
Generally, our recommendations for bylaws is sort of have the bare minimum, which is basically saying that the assets are going to go to another organization. As I think Stephen, who did the AG panel earlier, said, there's also a requirement that not only to be another exempt organization, but an organization similarly situated, right? So that's the language you utilize. So another organization could be a church in your denomination. It has to be somewhat similar to what your organization was formed for. So it's keeping all that in mind. And that's part of sort of looking at sort of planning the dissolution process.
Yeah, it's important to note there's sort of 2 aspects to any dissolution. In this part, churches struggle with this, I think particularly, is that charitable funds are restricted funds from donors in most cases. And when you do a dissolution, you're not just dealing with the not-for-profit regulations surrounding dissolution, but you're also traditionally dealing with charitable regulations as far as donor-restricted funds, right? In fact, according to the Attorney General of the state of New York, every donation to a charitable organization has an implicit restriction that is the corporate purpose of the organization.
Yeah. So yeah, we'll go into that.
We'll go in that
more detail. Yes.
Must you have a building to qualify as a church?
No, ma'am.
No.
So to be clear, because I myself have this, I'm to blame. I am not without sin. The word church is a shorthand that we use because it's used for the IRS regulation. The real word that we're actually talking about here is religious corporation for the state of New York and church. But because English is a fun language, church is also the name of the building. We are talking about the legal corporation in this instance and the tax organization. We are not talking about the building except the specific times that we're talking about a building, which I'm sure is very clear.
Yeah, and I think there's a distinction. You don't necessarily only want to dissolve if you have real assets. You also want to dissolve because you want a formal process in place to address the liabilities, put the state on notice and the public on notice that you no longer exist as an entity, right? But so you could still not have a church location doesn't mean anything, that you don't have to go through the dissolution process, I guess.
Yeah.
Okay, paths towards dissolution, as sort of spelled out in the religious corporation law, section 18 provides for 3 different sort of paths to actually dissolve, right? The first is a majority of trustees decide to file a petition to dissolve the organization. Second is a majority of the remaining members say trustees are no longer there are no trustees, there have been elections. The 6 members decide they want to now dissolve the organization, they can go through the process. And there's a weird sort of caveat that says basically majority of remaining members that reside in that county. A lot of the religious corporations law focuses on the fact that organizations were incorporated and were locally based. So that's why you have the counties sort of holding the certificate of incorporation, but also when it comes to the majority of remaining members being in the county where the organization is located. And then the last is, do you want to?
Ecclesiastical governing bodies also have the ability to dissolve a corporation. I will say that the way the statute reads, we kind of try to mirror here. It's
The preference, yeah.
it goes down the line. Question one is, do you have a majority of trustees remaining? If yes, do this. If no, go to remaining members in the county. If no, do this. And the last step, if everyone's gone, they've closed the doors and they've absconded, the denomination has the ability to step in.
And in that scenario, oftentimes the denomination will take over the property and also will take on the liabilities and don't necessarily have the mandatory sale process that sometimes you have with 1 and 2. And we'll talk about that, right? There is oftentimes, and I'm sure it's in sort of, we'll talk about that later on.
I want to note that this is also denomination neutral as well. This is one of the few statutes that is actually denomination neutral. So even though you may not have a specific provision in your ecclesiastical tradition about dissolutions and the role of the denomination in that, this applies.
So what do you need to have in place and what documents do you want to have when you start thinking about the dissolution process and planning sort of the legacy of that organization, right? The first is having the formation documents. Those are the certificate of incorporation, any amendments to those certificate of incorporations that were filed in the county. I think that's also something that it's not really an official amendment unless it's been filed. So although you may have, we've amended it multiple times, but you didn't actually fully adopt it and notify the county, that becomes an issue. So oftentimes we say, if you don't know, say it's an older organization and you don't know if there's been multiple amendments, is you just go to the county clerk, whoever you filed this certificate of incorporation with, to see what amendments have been made throughout that process. The second is the corporate governance documents. So that's the bylaws, right? That will really mandate sort of a lot of things of, does it have a dissolution provision? Is it, specific as to where the assets go? All that information. And then also getting a good sense of the financial picture of the organization. That's, having a good financial statement, understanding all the assets. So that's, real property assets, any investments, any bank accounts, any restricted funds, understanding all the assets, clearly, and then also understanding the debts and liabilities of that organization.
I think it's important to always remember the why. The law does not ask for these documents. Lawyers do not ask for these documents because I like looking at papers on my desk, although if you saw my desk, you would think I did. And it's because that you have to go through these processes, right? I think David mentioned this, but the question was like, well, what if we have a dissolution provision in one of our corporate documents? You have to provide those corporate documents to either establish that you do or you do not. So there is a reason for this. It's not just the required documents. It's the required process that you have to do to get started, to go through all these documents to figure out what you're doing.
Yeah. And I think also when we talk about assets, and I will say this, is that understanding sort of the actual assets you own, legal descriptions, seen oftentimes there's churches or organizations that have assets, they don't have an updated survey, don't actually know the property they own. I think that's really important. Understanding what the actual market value of that property is. So doing some diligence on getting an appraisal. And when it comes to liabilities, is understand sort of, are there any liens associated with those real property assets? Maybe there's an ancient mortgage that's filed that was never really fully satisfied. You want to make sure you understand all of that. So you need to lay that out in your plan of dissolution and making sure that is settled as a part of the process.
And I'll also point out, because this always comes up, I always get a question, well, the church has a piano. Someone wants the piano. Do not give the piano to a church member. But that is a level of the difficulty of these things that you have to think about, is assets are not, everyone loves to talk about the property, right? Like the property is very important, but there are other assets, not just cash assets, that the church has. There's a piano, there are other things, there are church records.
A lot of other
consider.
Stained glass that maybe have a financial significance. And just think about that. I think this is also a good point of talking about members getting.
This is a general prohibition and this is about the shareholder thing that if you were in the other session, is like members should not be getting a pecuniary benefit, which is just a benefit, basically, for being a member. And that includes getting the piano when the church closes. Yes, ma'am.
So, talking and I were laughing about an ancient mortgage.
Uh-huh.
And I shared with them, we go to ancient mortgage. Because what's interesting is that there may be an ancient mortgage because people, you never know, could have been taking out equity loans against the property to generate whatever funding or pay for whatever bills. Is that something that you see with churches?
All the time. Yes.
Yeah.
And so, and we were like, what, ancient
Yeah.
mortgage? So we were like, wait a minute, maybe it was equity loan. So, and that's something to consider.
Yeah.
You know, not knowing what kind of deal was made or thinking that things were just automatic and not knowing that it was like a lease or a sublease or just a gift from the owner. Let's say somebody passed away and then their estate was like, okay, you gotta start paying now. It's like, but I thought we were here for free, so.
Yeah,
That is a great point, because let me just tell you, from your lips to God's ears,
Oh, yeah.
what happens all the time is so-and-so died and left us the church and says it has to be used as a church from until glory. Yes, ma'am. That happens all the time. And then we're stuck with a piece of property that we're like, we're going to dissolve. And then we realize, oh, wait, we can't dissolve and transfer the property and sell the property because we can't sell the property to liquidate the assets because the property can't be sold because the property has to be used as a church forever.
You transfer it to another church.
We'll have to talk about the reversion. But these are real things, and this is why you have to go through this, because if you want to talk about 11th hour specters, we've seen them.
Yeah, I also think another example of the mortgage situation is, say someone contributed $50,000 at the time they were building the church, and it was a mortgage to help build the church, right? And maybe the payment's already been done. It's been 100 years at this point, but there's no actual satisfaction of that. We just want to make sure you understand if there are any mortgages, where is there proof of payment? Maybe not, but maybe it's you going to the estate of that individual to understand that they're not coming after those loans. But you have to do some diligence here, and that's why we really say it's important to sort of understand what liens are with the property, which ones are validly existing right now, which ones are, are they ancient? Is there another explanation there? But having the information is really important early on.
And that's another aspect of the charitable donation restrictions that you have to think about, because that also applies to funds, for instance, and other things.
Not necessarily. It could be more than that. Someone could just actually, record a mortgage against the property and it's still there from 50 years ago.
But for 3B or 3A,
Oh,
what is
it
that?
should be B.
But
Good
do you
catch.
suggest that everybody that if you're thinking about closing, that you do a UCC1 lien search? Are there any other searches that you need to do?
A title search.
Yeah.
Just a title search.
Generally would say that they should do a full title search, and that is also, a lien search, violation search, understand sort of what encumbers the property. Obviously a violation is not necessarily an encumbrance of property unless it turns into a lien. There's a whole thing there, but you want to make sure you're addressing all those issues early on. And so when I say sort of financial documents, list of assets, have all your bank statements, have a list, have some sort of financial statement in place, have appraisals, list of debts and liabilities, do a lien search, get a title search to see what's on any real property. You can also do, an asset search if you really don't know there have been really bad recording over time, but maybe there are assets out there that you just don't know about. You can do an asset search as well, but it really depends on each organization and how well they've maintained their corporate records throughout the process.
And I think, I can't remember if you mentioned this, but we also recommend doing a corporate document search as well with the county. A corporate document search.
Yeah, I just did mention that earlier. So
Yeah.
going down to the county clerk, getting your full records of the certificate of corporations and any amendments that you have
So
filed.
basically search for everything. You should have literally come with the receipts for all of these concepts, right? I think that's what we're talking about, this being an involved process, is all of this isn't just, there's some due diligence to make sure that the records that you have are correct.
So I just have a question because I learned today, this is the first thing I learned, that the AG is supposed to approve mortgages on churches?
That's correct.
Okay, so then the AG would have records of that? If there were mortgages
Not necessarily. Not necessarily, but I will say some denominations don't have to go through the AG. And so there was a statement that was made sort of quite broadly that the AG has approved everything. There are some denominations, your denomination that you're here for specifically.
for free, but
Oh, okay, one of them at least would only go to the Supreme Court, right?
Right.
So if they went through the Supreme Court approval process, you could find that, right? If it's depends on when it was occurred, you can go online and find it, or you go to the county clerk and they would have a copy of the order approving that mortgage. But I will say it's not the original mortgage. That was the other thing that I think was left out in her comment, is that for a religious organization, it's only a refinance. So if it's at the initial inception of the, they're buying a property and at that point there's a mortgage taken out, that does not need to be approved.
Okay.
It's only when you're refinancing that mortgage.
Or getting a new mortgage.
Or getting a new mortgage that wasn't a part of a purchase.
Purchase money mortgages are exempt.
Yeah, that's actual language, thank you. So there is a distinction there, right? So oftentimes that's not
Exempt
part
from
of it.
requiring Attorney General or court approval.
So,
Yes, ma'am.
sorry.
And I will say that with the AG's office, they have an online database of all their approved transactions. Obviously, I think there's a date period. I forget what they go up until, but you can search it, make sure that there's any approvals are there. With the court, you also can search for it. If not, there usually should be a hard copy with the county clerk.
There's also a canary in the coal mine problem in the sense of like, if they did what they were supposed to and got Attorney General approval, it will probably also be recorded. So it's really the ones that don't do the things that they are supposed to that causes the problems.
Yeah.
Yes, ma'am, you had a question.
Well, it's digressive, so maybe I shouldn't digress.
Okay.
So-
I'll ask you later.
Okay.
Yeah. The next slide is establish the plan, right? And this is once you have all the information at hand, you understand what assets you're talking about, you understand the liabilities that you're going to have to settle as a part of the dissolution process, is understanding sort of like creating the plan. The first thing we always say is sort of look at the requirements set forth in the formation documents, right? So if your formation documents specifically say we were incorporated on X day and it will be, once we dissolve, all assets go to XYZ organization, then you need to, unless you've amended that out, you have to follow that restriction. Also, if you are part of a larger denomination and they have restrictions on your assets, you're going to have to figure that out as well. The other thing is donations. Someone gives you a contribution saying, I'm giving you $100,000 to put in a new elevator, right? Understanding that those funds are really restricted for that new elevator, it becomes a little tricky about, once you dissolve, where those funds go. But there's a whole process you need to have in place, and understanding the restrictions on any of your assets early on is key, so you actually can know, what you need to do with those assets.
Yeah, because it may slow down this process even further, right?
So once you have understanding the restrictions as it relates to the assets you have, understanding sort of the settlement of the debts, right? Ostensibly, New York State is not going to be okay with you dissolving with outstanding liabilities. And if you do have a lot of liabilities that your assets don't cover, they want to make sure that your creditors are on notice. There is a due process for them to come forward and sort of negotiate what that settlement looks like. But there's a lot more that goes into it if you have insufficient assets. We're going to use the fact that like you have your biggest assets, your church or your house of worship, and you might need to sell that in order to settle your assets.
Yeah,
Settle your debts.
Yeah, I will say that sometimes and very often what you see with this, because of the nebulous record keeping, is what may happen upon dissolution is an organization may just assign all of their liabilities to the denomination or whatever organization is succeeding it, right? I mean, it may not always be the denomination, it may be a sister congregation. You will often see that as a shorthand to settle the liabilities, because settle does not mean pay.
Yeah. And then I will say the statute specifically talks about under RCL 18 that you can sell the property to settle the liabilities. However, I don't think that is I don't think that's the statute's first where they want you to go. I think they want you to transfer the asset to another organization that's going to utilize it in the same way. Obviously, that really depends on your sister organizations, especially if your sister church does not need that, for example. You just have to sort of understand sort of the transfer process.
And I'll say this is important. It's important to note is that, with anything in the religious corporations law, a lot of this is subject to interpretation and legal opinion. So specifically regarding Section 18, is I know David and I have very particular opinions that we feel very strongly about and we feel are supported by law, but other lawyers may not feel the same way. And so I think it's important that even as we sort of are presenting our understanding of the law, that you consult with an attorney, because different lawyers may have a different opinion.
And it really also, the facts matter. It really
Yeah.
does. The facts matter, the organization matter, the liabilities, understanding what type of liabilities really do matter when you're thinking about your plan of dissolution. Yes,
So this is obviously a long process,
for sure.
and it's a process that takes expertise. So, what kind of budget or timeline is typical? Like, for example, as an institution, we need to anticipate that this is a 24-month process by the time you get through the AG's office, and $50,000 in various expenses to prepare documents and filing. Like, what are the parameters, or is there no general?
It's tough because it's so fact specific, right? Like, for instance, let me tell you the one thing that's going to initially complicate this problem. If you have property that you need to sell,
You need approval of.
not necessarily. That's that's something that you should consult with your lawyer about, whether or not you can get the transfer of the property approved and pursuant to the dissolution. But as a practical matter, you have to negotiate a sale with a purchaser, which is a whole, usually its own little ordeal. So you have that micro piece of the larger dissolution process, which everything else, you can burn the candle at both ends to a limited extent, but you are then dealing with the purchase, right? You're negotiating the purchase as a component of the overall dissolution. If that's the facts that you have, which is a very common fact for a lot of religious organizations, that just, the market's doing better, but, closings were not happening for the last 2 years for the large part. That delays your entire dissolution process because you're waiting for the property to close in order to pay off all your debts so you can actually formally dissolve.
I will say one thing that sort of, the AG is actually not a part of this process. And I think that's actually, the slide is perfect for this, is that once you have a plan for religious organizations, the Supreme Court has to approve the dissolution. The AG is actually not involved for religious organizations. It is involved for not-for-profit organization. And that's a separate process. I want to make sure we're sort of delineating the fact that here we're talking about religious organizations, which would automatically go to the Supreme Court. And so I will say you don't have to go through sort of the months and months and months of waiting to hear back from the AG's office on certain things. But so it's a little bit different with that. And I was going to say something else and I totally forgot it.
I just want to be clear that there may be a situation that even though you're dissolving, you may need to go to the Attorney General for approval of the sale. That may be a situation. I recommend that you consult with your attorney and their legal expertise about what actually they feel comfortable doing and what they believe they're supposed to.
And that's why I said it's preferred that you're not actually selling the property. If you don't need you don't need the cash to settle assets, settle the liabilities, then it's really a transfer of the property. And there is sufficient guidance within the RCL of a transfer for zero or nominal consideration, right? So it really depends on your situation. I think the idea oftentimes is you're transferring the real property, everything to another organization, and settling the debts utilizing the cash you have on hand. However, there's oftentimes you're at a point where you don't have enough cash and you need to actually sell in order to have enough financial wherewithal to actually settle your liabilities. Yes.
Does it matter where you were incorporated that determines if you have to go through the Supreme Court for the dissolution?
So any religious organization formed in New York State and existing in New York State has to be dissolved by the Supreme Court in the county where it's currently, has its principal place of business.
What should be the same place as where your certificate of incorporation is. However, that's not always the case.
There's oftentimes, there's some nuances of that. Like there's some churches sort of on the corner, on the
To use the
border.
Bronx Manhattan example, you may have moved, right? And so you were originally incorporated in Manhattan and now you worship in the Bronx.
Or Nassau and Queens. There's at some point part of Nassau County was part of Queens and sort of that, maybe the certificate of incorporation is with Queens County, but you're actually now existing in Nassau County. You would go to the Nassau County Supreme Court to get that approval.
Yes, ma'am.
So if in your building, if you are, let's say, looking for a partner, you can no longer take care of your building yourself. Does the AG get involved if, let's say, you're now going to share your building with another nonprofit?
It depends on how that relationship is negotiated. Traditionally, for religious corporations, a lease in excess of 5 years, so 5 years plus, has to get Attorney General approval. So the counterfactual there is 4 years, 11 months. Would it have to get Attorney General approval? I will say that there is some legal scholarship that done by me that says that if you that I actually am of the opinion that which we don't that a church may have to get approval if it transfers all or substantially all of its assets. I think but
But if it's like if we did a 10-year,
If it's a
Yes.
lease with another organization, then yes, you need to get approval for the AG. That's a sort of separate religious corporations law 12, and then that's sort of outside of this. But I also say that you have some sort of partnership or sort of merger consolidation event. There's another whole process on doing that. And do you want to say 2 words on that?
You can merge. It's actually kind of similar in the sense that what you do is instead of a plan of dissolution, you do a plan of merger, and then you file with the court. I will say certain denominations have the ability to avoid the court, but in most processes, you will go to the court. Now, I actually want to just follow up because this is an extension of the question that she asked, is the fact of you cannot do this by yourself because of the court involvement. Corporations cannot appear pro se, which is what all of the churches that we are talking about here should be religious corporations in order to dissolve under Section 18. So you actually have to have a lawyer.
That was what I was gonna ask too. Like, do you see churches trying to do this themselves, or they almost always hire counsel?
I will, to be clear, what I'm seeing mostly is churches not doing this at all, and they should be.
Yeah. You walk out the door and let coffee on the counter.
And there's also, and then if you at some point want to sell property, right, you sort of have to say in your petition to the AG's office, Supreme Court, is whether or not you're contemplating dissolution. They're going to want to know why or not there's members, what happened about that process. But oftentimes, if you're at the point of, like, there's no one there, they say you really need to be filing Section 18 petition to dissolve and sort of formally dissolve the entity and making sure all the property goes to the right place.
To get around the extended time lease, the 5-year lease, could you do a lease for 4 years and 11 months and then have an option to renew?
No. So options to renew are considered a part of the overall term. So to give you an example, let's say you had a 4-year lease with an option to renew that was for 3 years. So the way the Attorney General and the way the regulatory bodies view that is that's a lease for 7 years. 4 plus 3-year extension.
So you wouldn't have to go to the AG?
You would have to go to the AG and you would treat it like it was a lease for 7 years.
Okay.
Yep.
And I'll say becomes a little tricky with the option situation because part of this you also have to, we're not really talking about real property transactions approval, but you have to also show that you're getting fair and reasonable consideration as part of it. It becomes hard to sort of understand what that value is for those 3 years. If you can avoid it, and also because you don't want to go to the AG process, negotiate the 4-year lease, and then at maybe the last year of the lease, you enter into some other negotiation to extend it. I also think it's just better for an organization to know, they've been here for 4 years, we work well together, now we're going to enter into another lease, understand the real value here for us, our organization, as opposed to having all these options. It's oftentimes just hard to do that. And I also say, like, if you're a board, right, give it to the next board to determine. Maybe it's the right fit, maybe it's not the right fit, but you don't have to make all those decisions now.
I also want to note, David brings up a good point, and it's what I want to sort of address is you have to be careful about doing an option to begin with because of those concerns. Because not only is the Attorney General going to treat it as if it was the total term of the lease, but you have to meet the fair and reasonable consideration. So what you usually see in the business world about options is, you will renegotiate the rent then, but you have an option. That's not permissible under the Not-for-Profit Corporations Law under its current interpretation because you're not making a determination of fair and reasonable consideration for the entire term of the 7-year lease when you're entering into it because you don't know what the rent's going to be starting in lease year 5.
So all this, my brain is like
There's a lot.
cycling. Well,
4
it's
minutes.
good because I'm thinking, is it better to as a church, but also align it with a, what they call social enterprise, such as a daycare center, that the church would be subleasing the space from the daycare center, and then when it's time to quote unquote maybe dissolve the church, it won't be such an issue that way. It would be more like the business of the daycare center is donating space to the church, and it's like a tax break.
So, well, so I will say in that, to use that example, to take that fact pattern out, is what would happen is if, like, I have like, I'll just give you an example, right? Like, let's say I represent a synagogue right now that has a daycare, right? Like, let's just say that happens all the time. Let's just say that that's the example.
But it's oftentimes where the synagogue is the landlord.
Is the landlord, exactly. Typically what happens in this situation, because you're thinking about the real property that you already own, you're the landlord. And then dealing with your subtenant is a headache you have to solve to dissolve. And maybe the easy scenario is transferring it to, but I'll be clear, not everyone who's a tenant wants to be a landlord or wants to be a property owner. They may be a tenant for a reason. So I would say it actually may end up being more headaches than it's worth, because then there are children involved also, like what's gonna happen to the daycare if you dissolve. And so it can become a complicated thing very quickly.
Yeah, right? If you're a church and now most of your money comes from business enterprises, you then have a different issue.
Correct, you may lose your tax exemption.
Exactly.
Yeah.
Your property tax exemption.
Yeah, your property,
Yeah.
and there's also UBIT
There's also
considerations.
UBIT.
Yeah, that's a separate thing.
Ironically enough, that's across the hall.
Talking about space sharing. One thing I did want to point out while we have a few more minutes, is that as part of the notification process, so you're submitting the petition to the Supreme Court for approval. As a part of that, you also need to put the public on notice, right? And you have to publish in some sort of newspaper in the county for 4 consecutive weeks that you're actually dissolving. And that's just in case for the things that we talked about, right? There's any creditors out there. Maybe there's members that have been meeting somewhere else and they didn't realize that the church wasn't being utilized, or the organization's house of worship wasn't being utilized, or something of that nature. So there's a notice component here that has to happen, which could add time to the process. You sort of have a plan in place. You decide you want to file a petition, that you have to put the public on notice, wait for that process to occur, and then actually file a petition in case someone wants to come in and say something or object to it, or want to bring in relevant facts that are needed as a part of the dissolution process.
Or a creditor coming out of the woodwork.
Yeah, that's I think what it's mostly for. It's also, they say the county, because if there are members that maybe they just haven't been going to church every week, but they want to get back into it, and they still are considered a member, as William talked about before, maybe that will sort of give them the notice to come back, and maybe there will be an actual viable organization there. But I have never seen anyone actually object. We've done this quite a few times. I've never seen throughout the process, the notice period, anyone come out of the woodwork. It's mostly because you sort of prepare early on, make sure you understand your creditors, understand sort of the financial situation there, and that actually know that there are no members or very few members, and the ones that are part of it have voted to dissolve.
I will say a little practitioner's tip here is that when you try to get this notice done, oftentimes what they will do is they will make you do it in the same publication that you have to publish things for when you form an LLC. I will say that while the formation of an LLC has very specific requirements, the requirements of the statute is slightly broader. So while that I think is sufficient, it will be a little bit more expensive. So consult with an attorney and someone who does this sort of publishing work to potentially save yourself some money.
Yeah, I think it's also, you want to make sure you're clearly stating the date and time and the requirements that are set forth in the statute as to the notification.
Yeah, and I would say this is a particular instance, because this is the particular site for how to do this in the actual law. To say is arcane would be wrong, because arcane things are complicated but clear, and this is just very horribly written.
Okay, so we have one last slide. And then so once you get the actual plan of dissolution approved by the court, and they've laid out the fact that you're allowed to sell the property, who it's going to, the money that's being received as part of that transaction, what debts and liabilities you're settling, they've sort of approved the plan itself, then you have to go and actually effectuate the plan, right? And I think this is a key thing. Just because you have an order to dissolve doesn't mean you've actually dissolved, right? You've only dissolved once all the liabilities have been settled and all the assets have been distributed. So there's still an ongoing requirement, and the fiduciaries need to still be a part of this process throughout, until you've actually given your last penny away to the organization.
Yeah, and it's important because if you look at this in the not-for-profit context, is not-for-profits actually have to go back to the Attorney General to be like, we did it. Like, give us a rubber stamp that we did what we said we were going to do. And in a religious corporation context, you kind of just, when you complete it, it is done.
Yeah. And I think that's it for now. I think.
Yeah. What's the time?
We're past.
Perfect. All right.
William, do you want to go just to?
Yeah.
3 more slides in, just a disclosure.
Sure. As always, this isn't legal advice. Consult your own attorney.
Yeah, I think it's, we try to, utilize our experience we've had. Obviously, everything is really fact specific, especially when it comes to dissolutions. So many restrictions, understanding denominations, understanding your corporate documents. Just want to make sure you're sort of planning ahead of time. And I think the thing that we maybe didn't hone in clear enough here is that we sort of look at this as could be the organization's legacy, right? So say you're an organization that's dissolving, is all these assets are going somewhere else. Ideally, it's someone or entity that's similarly situated, so they're carrying forward that mission that you've had, but it's really thinking about what is the next chapter for your organization, and making maybe another organization financially stronger in the process is key also.
Yeah. Something I tell people all the time is like, as a not-for-profit, as a charity, your obligation is not to maximize the assets of the corporation. It's the duty of obedience to the mission of the organization. And so your conduct should be informed by that, not by maximizing profit.
Yeah. And I think there is something honorable about saying, okay, this property is going to be utilized in some other way with a similar mission.
Yep.